Hello, my name is Jay Chauhan. I'm a lawyer in Richmond Hill, Ontario. I'm also called to the bar in England at Lincoln's Inn and also in an advocate in India. Most of my practice has been in Ontario, and today I'll be talking about how to prepare your bill to the client. Unlike other professions, I think we have a bigger challenge as lawyers trying to figure out how to bill a client because the services we render are not as tangible and specific as they are in other situations. So I'm going to briefly talk about my experiences all my career, and here are some of the observations I make. So first of all, when you prepare an account, what things should you take into account? You would take into account your retainer. What is it that you say you will do for the client? Secondly, you would look at the amount of claim that you were preparing for, if you did a contract, how long it took you. But it has to be a sense of proportion. If you were writing a major contract or you were doing some litigation where the claim is, for example, a small claims court under $25,000, and then the claim may be, let's say, 15,000, and you send a bill of 5 to 10,000, it's a little bit disproportionate. So you should relate the bill to the amount. And I think there's other criteria that we have in Ontario under Solicitors Act, which include that how urgent it was, importance of the matter to the client, and the skill, your reputation, number of years in practice. All these are relevant factors that you have to take into account when you're preparing a will. I'm talking about the bill, actually. So when you have those overview picture in your mind, including what have you billed in the past in that particular file. Is this an interim account? Is it a final account? For example, you have one-time events such as a will, then you want to just bill for a specific item and you don't have to look at the past. But you look at the past to say what have you billed up to that point in time, and then you have a perspective of the time, the problem that you dealt with, some event that you completed. That's a good pause or a moment when you can send a bill to the client. I think in terms of then the next step is deciding the amount of the bill that you should send. So what is the criteria or the method by which you would decide on the quantum of the billing? So as I said before, I think it has to be proportionate. But one of the important factors in your mind is your particular experience, seniority in the profession is definitely an important factor. Because if you have to go to the assessment court to have your bill assessed and collected through the court order, or you go to the small claims court and ask the judge to make a decision, then there are certain criteria that the deputy judge or the assessment officer will take into account, and that perspective of what they will do in the assessment arrangement is very significant also in terms of your decision. Because if you end up there, then I think that you don't want your bill to be reduced in amount. But you can just take it from me, from my experience, that anytime you take it to the court or even assessment officer, the bill will be likely reduced. Actually, that's just the way it works. But I think I spent 24 years as a deputy judge until I retired a few years ago, and I made many decisions. And my own perspective also was always that that somehow when you are doing the work, in the legal work, is not quantified. Therefore, how much research do you do? How much time you spend on a statement of claim? How much preparation did you do for the trial? All these things are somewhat, I would say, intangible and therefore difficult to assess. So when you go to court and have your bill assessed, as a lawyer, then the question is what is reasonable that you should ask for in the claim. So I would suggest that you keep that perspective in mind. So then you come to the point of actually preparing the draft of the account. So should you use a letterhead? I would say that for many years I didn't use a letterhead. I simply said statement of account, with the office of, let's say, J. Chauhan, and therefore you just wrote out the time record, and that's one way of doing it. The other method of doing it is that where you quoted the fee for the particular task that you're doing to the client, then you have to stick to that one. So, and then of course you have to, in Ontario, which there is an HST that you have to charge, and then you add the HST, and then you total up the amount and you send it to the client. Now, if you have trust funds in your account, then you can write a check and move the funds from your trust account to general account. But I think in terms of the formatting, you write the letterhead, and then you can see an example of this one actually, that there is a letterhead, and then the subject matter you dealt with, then the items that you dealt with, and then of course the amount, etc. And then there's a place for signature at the bottom. And some of these requirements are also part of the requirements of how the Law Society wants you also to bill. That means you convey the message to the client, this is the services that you provided. The thing to keep in mind also is that Ontario jurisdiction is particular in terms of the responsibility of the lawyer, which is enforced very vigorously here, and therefore you have to keep in mind that how, for example, would you come across, for what service did you render? So it's very important at the same time that you write a reporting letter. So when you write the reporting letter, the way you should write is that you are summarizing the events that took place, what you did. The client gave you confirmation of what you have done, and he asked you to do. And the way you write your account is very, very important, because this account may be reviewed not only for assessment as to the amount that you would be eligible to collect from the client, but also the way the matter can be played out in negligence for a lawyer. And it's very common that if you make an account that is not, so to speak, palatable to the client, then you can end up making an allegation that you were negligent. This is very common. So I think one of the things that you want to consider is that how is the client going to react? And then if you kept him informed, kept in touch with him, developed a rapport with him, then I think it is easier at the time of collecting the bill that you present the bill to the client, and is more agreeable to writing out a check. So developing the client relationship between the lawyer and the client is also very fundamental to the way you bill. So I hope that some of these guidelines are helpful to you, and I'll be doing frequent videos at Angel Mentorship Group, where we now have almost 270 people. Join the group. Anyone is entitled to join, and you can just ask for it on the Facebook. I will admit you, and you can be a lawyer, paralegal, or an interested party in terms of how you want to learn the law as a citizen. But all of you are welcome, and then share the ideas, make comments at the bottom, and ask your friends to join as well. Thank you.